Laws in Alberta prohibiting sexual harassment in the workplace. This session will provide information about the laws governing sexual harassment in the workplace in Canada and more specifically in Alberta. Before learning about the applicable laws, we will consider a quick recap of what a workplace is and what sexual harassment is.
What is a workplace? A workplace can be described as a location where an employee performs work for their employer. It is not restricted to conduct that occurs in a physical workplace location, but also includes conduct that occurs outside regular work hours, such as on business trips, at company parties, or other work-related functions. But that has implications for the workplace.
What is sexual harassment? Sexual harassment is discrimination based on gender, which includes discrimination based on sex, sexual orientation, gender identity, and gender expression. The Alberta Human Rights Act prohibits discrimination in the workplace based on 15 grounds. The Alberta Human Rights Commission describes sexual harassment as any unwelcome sexual behavior that adversely affects or threatens to affect, directly or indirectly, a person's job security, working conditions, or prospects for promotion or earnings, or prevents a person from getting a job, living accommodations, or any kind of public service.
Laws governing sexual harassment. Generally, there are various laws in different legal areas protecting against sexual harassment, including human rights law, occupational health and safety laws, criminal laws, family violence laws, and industry/professional codes of conduct. In Canada, protection against sexual harassment is provided through the Canadian Charter of Rights and Freedoms, a constitutional document, federal and provincial human rights legislation, and human rights tribunals and court decisions applying human rights law.
Alberta legislation offering protection against sexual harassment. Alberta Human Rights Act. The Alberta Human Rights Act prohibits discrimination in 5 protected areas and on 15 protected grounds, including on the basis of sex, gender, gender identity, and gender expression. The Alberta Human Rights Act does not define sexual harassment. Occupational Health and Safety Act. The Alberta Occupational Health and Safety Act defines harassment and violence as workplace hazards and requires employers to help prevent workplace harassment and violence and address incidents when they do occur. Collective agreements. Unionized workplaces have collective agreements that employees can grieve under if they have been sexually harassed in the workplace. Non-unionized workplaces. Claims of sexual harassment can also be brought in non-unionized workplaces by bringing a claim under civil law, although you cannot sue for sexual harassment alone, as this is covered by human rights laws.
Duties of organizations to prevent and respond to sexual harassment. Organizations regulated by the Alberta Human Rights Act under the 5 social areas must take positive steps to maintain poison-free environments that respect human rights. Organizations violate the Alberta Human Rights Act if they, directly or indirectly, intentionally or unintentionally, infringe the AHRA or authorize, condone, or adopt behavior that is contrary to the AHRA. From a human rights perspective, it is not acceptable to choose to stay unaware of sexual harassment, whether or not a human rights claim has been made. The Occupational Health and Safety Act imposes an obligation on employers to take all reasonable measures towards ensuring a safe workplace, including a workplace free of violence, which includes sexual violence. If a complaint is made about an incident of harassment or discrimination, the employer is obligated to take this seriously and investigate.
What is a poisoned environment? Sexual harassment includes conduct that creates or allows a hostile or poisoned environment. A poisoned environment is discriminatory because people face terms and conditions of employment, tenancy, education, etc. that are quite different from those experienced by people who are not subjected to the harassment. This leads to a denial of equality under the Alberta Human Rights Act. What should you do if you are sexually harassed at the workplace? If it is safe and comfortable for you to do so, confront the harasser and tell them to stop. Keep a record of incidents at the time they occur. Date, times, locations, possible witnesses, what happened, your response. This is not required to make a complaint, but such a record will strengthen your case and help you remember the facts rather than relying on your memory. If the harassment continues, make an internal complaint to your employer through your department manager, human resources department, or some other person in a position of authority. If applicable, make a complaint to your union or employee association. Follow the steps outlined in your employer's internal harassment complaint policy. Employers have an obligation to make their workplaces free from harassment, including sexual harassment, and it should include an internal harassment complaint process. You can file a complaint with the Alberta Human Rights Commission. Keep in mind that there is a 1-year limitation period for filing a complaint. For example, you must file the complaint within 1 year of the last occurrence of sexual harassment. You may also decide to file a civil lawsuit against your harasser and your employer. You can bring a civil claim for wrongful or constructive dismissal if you are unable to work in the environment because of sexual harassment. The grounds for the lawsuit may include, but are not limited to, torts and assault, negligence, sexual assault, battery, harassment, and intentional infliction of mental trauma. Sexual harassment may also constitute an offense under the Criminal Code of Canada. The offender could be liable for assault, Section 266 of the Code, sexual assault, Section 271 of the Code, sexual assault with a weapon, Section 272 of the Code, or aggravated sexual assault, Section 273 of the Code.
Who can make a complaint under the Alberta Human Rights Act? The Alberta Human Rights Act states that anyone who has reasonable grounds for believing that a person has contravened the act can make a complaint. This means that either the sexually harassed person or any other person who is aware of the harassment may make a complaint. The process for making a complaint is outlined on the Alberta Human Rights Commission's website.
How do I know if my complaint falls under provincial or federal jurisdiction? Any alleged incident of discrimination must have occurred in Alberta or with an Alberta organization to be within the Commission's jurisdiction. Most employers, service providers, and organizations in Alberta are governed by provincial human rights legislation, which is the Alberta Human Rights Act. However, some are governed by federal human rights legislation, which is the Canadian Human Rights Act, and fall outside of the Commission's jurisdiction. Can I face consequences for filing a complaint about sexual harassment? No, you should not. It is unlawful for anyone to retaliate against you or someone who provides information or helps to investigate a complaint made under the Alberta Human Rights Act. Under the Occupational Health and Safety legislation, when a complaint is made in good faith, the complainant cannot be subjected to any penalty.
Remedies. The Alberta Human Rights Commission investigates complaints and can recommend either financial remedies or non-financial remedies. The possible remedies under the Alberta Human Rights Act include orders to cease from discriminatory acts, orders to refrain in the future from committing the same or similar discriminatory acts, providing the complainant with all rights, opportunities, and privileges denied, compensating the complainant for wage loss, expenses, injury, taking any other action the tribunal considers proper to place the person in the position they would have been in but for the discriminatory act. For example, general damages, interest, issuance of apology, attendance at educational seminar, putting a sexual harassment policy in place.
I am an employer. What steps can I take to prevent sexual harassment in the workplace? Commit to providing a workplace that is respectful, safe, and free from discrimination, harassment, and violence. Put policies and procedures in place that promote a healthy and respectful workplace. Provide training for employees on how to foster a healthy and respectful workplace. Investigate complaints of sexual harassment at the workplace and enforce appropriate corrective measures. Ensure that complainants are not subjected to any forms of punishment or re-victimization.